This podcast is a product of the Florida Academy of Collaborative Professionals. Nothing in this podcast should be considered legal advice. To find a collaborative professional near you, visit www.collaborativepracticeflorida.com. Hi, I'm Catherine Eaton, a family law collaborative attorney. And on today's FACP podcast is Nancy Brodzki. Nancy is the founding partner in her law firm of Brodzki Jacobs. They're located in Coral Springs. Nancy graduated from Tulane University and the University of Miami Law School with honors. She was admitted to the Florida Bar in 1986 and is a board certified in marital and family law and a Florida Supreme Court certified mediator. Her practice is focused on collaborative family law, family mediation, complex family law matters, and LGBT family law. She's been a leader in the legal battle for marriage and divorce equality and LGBT rights. She filed the first challenge to the state ban on same-sex marriage in September 2013 and obtained for her client the first same-sex divorce in Florida as a result of that successful constitutional challenge and back in December 2014. So welcome, Nancy. Thank you for being a guest on today's podcast with the Florida Academy of Collaborative Professionals.
Thanks,
And
Catherine. Great to be.
I would like to start our conversation off with, how did you start? You've done so many things, but how did you start practicing collaborative law?
It happened at an AAML institute, and I think it was in 2005, where there was a collaborative presentation. It was the first time I'd heard about collaborative. It was, like I said, I think it was 2005, because I trained in October of 2006, I believe. And I was immediately struck by the concept. And I remember turning to the person I was seated next to, and I said, "Where has this been all my life, all my professional life?" And and I think I said, "And how did I not know about this?" So you don't know what you don't know. And immediately I came back to Broward County, where I primarily practice. And I started looking around for collaborative resources and found what is now the Collaborative Family Law Professionals of South Florida, also known as the Broward County Collaborative Professionals Practice Group. And I registered. I became a member. I hadn't even been trained yet, but they had a website. Even back then, Broward was at the forefront, and they had a website. It might not have been the greatest website, but it had a list of all the professionals who were members. And lo and behold, not more than a few months after my name was on that website, I got a phone call from a client who was specifically looking for a collaborative attorney because her husband had hired a collaborative attorney. Her name is Lori Barkus. Lori and I knew each other already as family law practitioners in Western Broward County. And she said, "You're on the list." I think the funny thing is she meant to call another Nancy, but I was first. I was the first Nancy in the alphabet. And so she called me, and that was my first collaborative case. I was working from my home back then. We did some of the meetings at Lori's office, and we did at least one of the meetings at my dining room table at my home. And it was amazing.
I remember, I'll just share with you one of my very first collaborative cases. We did the meeting at the party's dining room table, and the professionals came to the parties. So
Yep.
it can be whatever the parties want. So let's go back to when you were at the AAML, first the Academy of matrimonial
American Academy of
academy.
Matrimonial Lawyers.
Exactly. When all the big hoo-ha family law attorneys get together to learn the greatest and update and learn all what's going on in family law. So you're at this conference and you learn about collaborative and you say, where has this been? What is different? What struck you as to this is so different, that such a different approach, or they're doing things different than what I've been doing prior? What was the aha takeaway?
I think the fact that the two lawyers were working together while each representing their own client's individual interests. And the way that it was a team approach. Now, that one was really only talking about two lawyers and two clients back then. We hadn't really even expanded the model on a regular level to include mental health professionals or financial professionals. Although in my once I got trained, when I went to the training, which was in Orlando at Barry University, and it was the famous Lone Star Training Group, and they were amazing. And that was when my mind really was blown, because then I saw the full interdisciplinary model, and it really opened my eyes. But in my very first case, we used an accountant because we knew we had some unique problems with someone who was a government employee, but who had topped out at the level he was earning. And so there's a rule that a government employee can't earn more than the president or something really weird like that. And at the time, the president's salary, I think, was less than it is now. Anyway, we had some very unique financial issues in regards to calculating income. And so we used an accountant to help navigate those issues. And we did successfully navigate the issues. But circling back to your original question about what really struck me, the whole team approach, it was, and the informality, the flexibility, the focus on what are the client's needs and how do we meet those needs as a team. And they were dressed casually. They were talking about, sitting down around the coffee. And I just thought that's like what my ideal world was, because I'd always worked cooperatively with other attorneys when it was possible. We all know family law, certain attorneys, that's just not going to be your reality. But so many of my colleagues were people that I truly enjoyed working with. And I said, wow, here's a model that will help me enjoy the actual professional work even more than I enjoy it professionally now, because there was an element of camaraderie among the two lawyers who were modeling this at the seminar. And I went, that's what I want. That's who I always like to show up as. And now you're basically telling me that if you're in this model, that's what it can always be, because only lawyers who want to model that behavior are going to do collaborative cases. And there are certainly lawyers who should not practice collaborative law because they do not have the desire to exhibit those kinds of characteristics. It's not how they're wired to handle a divorce case. I get it. Not everybody's meant to be a litigator. Not everybody's meant to be a collaborative attorney. And the important thing is to know which one you are.
Yes. So one of my favorite things about collaborative is the creativity. So when I think of collaborative in the capital C, I think of creativity and how the process lets the professionals be creative, because the parties don't understand that a judge is limited to making certain decisions about certain things. But when you're in the collaborative process, that you can be creative. Will you talk a little bit about you were talking about the different models. So talk a little bit about the different models that we use in Florida and that are used all over that help people come up with some creative solutions.
It's a really good point. The truth is, statistically in Florida, only 5% of all divorce cases are actually decided by the judge. 95% of them are they either result in a reconciliation or the parties reach an agreement through one of three. There's always three other ways to get to that final outcome of a divorce other than leaving it up to the judge. And essentially, there's collaborative divorce, there is mediation, and there is direct negotiation. And direct negotiation is kind of the first one that falls off the possibility list because let's face it, two people who are getting divorced, no matter what the triggering event for the divorce was, divorce is rarely just one thing happened and that was the end of the marriage. Most of the time, it seems to me, with 40 years of experience, that it's a long, slow process of reaching a breaking point. And one of the things that seems to overwhelmingly be lost among the parties is the ability to communicate effectively about difficult topics. And they've lost that ability. So how are you going to directly negotiate with somebody that all you do is argue with and you're talking kind of past each other because neither one of you is listening to the other because you're feeling your feelings and you're angry and you're betrayed and you're all those emotions that you're feeling. So direct negotiation is usually the first one that people go, well, that's not going to work. We can't exactly sit down at the kitchen table, write this out on the back of the pizza box, and then take it to somebody and have it written down. So that leaves you with two other viable options other than leaving it up to a judge. And those are mediation and collaboration. And both of them, both processes are designed to help the parties reach an agreement while hopefully getting the insight, information, education, and legal advice supported not in mediation, not from the mediator, but hopefully from supporting attorneys, consulting attorneys as part of the mediation process so that the parties themselves are making the decisions. So, collaborative, I like to say, is like mediation, except with even more structure and with even more resources. And whereas in mediation, if I'm the mediator and two people come to me and they want me to help mediate their divorce, I am encouraging, urging, persuading, doing everything I can to get them to get outside legal advice as part of the mediation process. I call it collaborative mediation. There's no, the exact term is irrelevant, but parties need both advice, but they need to have self-determination. And what really makes collaborative and mediation head and shoulders above going to court is that the clients control the outcome, because nothing bad happens in mediation or collaborative process. What happens is you solve problems. You analyze the universe of information of the family with people who are qualified to help you understand it. You then discuss and generate all the different options that are available to solve each and every issue that the clients bring to the table, because it's the client's life. We're coming into their movie halfway through. They've been there since the beginning. We're kind of trying to piece the history together from what they tell us, but we weren't there to observe it. Now we're just seeing them in this limited capacity. And we're trying to problem solve. So after we generated all these options and eliminated all the ones that just are rejected for whatever reason, we are left with the viable options and then trying to turn to making decisions. Both mediation and collaborative are structured processes when they're at their best. People know what they're going into when they're going into a meeting with the mediator or the collaborative team to discuss um, the case, what the issues are. And again, you can be creative in both of these processes. Whatever the parties can agree to, I think there's only like two things you can't agree to in a divorce case. You can't agree to, quote, waive child support, but you can get creative and you can make it so that child support is zero, but it's not being waived. There's an explanation, and it's an explanation that will pass muster with the judge who eventually has to approve any agreement. And you can't agree to commit a crime. And I've never seen an agreement where someone tried to agree to commit a crime. So it's a pretty low bar about what you cannot agree to in collaborative. And, you know, things that you can't get in court, the list of things you cannot get in court is huge. You can't.
That's what people don't understand, Nancy,
Yeah.
that there's so many issues in a family that the court cannot consider. List a few of them. Just give a few examples that people
Okay,
think, oh,
right
the judge
off,
will take care of it, but the judge
right
can't.
off the top of my head, college for your kids. Off the table, judge has no jurisdiction. Who's going to pay for the child's car when they're 16? Good luck with that. Won't be in your final judgment in front of the judge with a 5-year-old. What about those lists of all those expenses that maybe you want to share? From the judge, you're going to get the most cookie cutter thing. How about a nuanced parenting plan that is really tailored down to family traditions and nuances? Yeah, from the judge, you're going to get like a chopped. It's like the difference between going to a butcher and going to a surgeon. You know, the judge is going to cut it into 8 quarters. That's it. In collaborative process, we can surgically go through each piece and separate it out exactly the way the parties envision it. And then there's things like how you're going to carry somebody on your health insurance while they are rebuilding their life so that they can make it through to the other side. Good luck. You're not going to get that in court. Again, there are just so many things on virtually every single issue. When you're talking about support, the court has to follow the law, and they're governed by formulas. In collaborative, again, you're not governed by the formula. You're only governed by a very, very, very low bar of, well, you can't waive child support, but you can sure play around with the numbers to get the result that the parties really want.
Those are great examples. So I thank you for sharing those. So talk to me about the privacy of collaborative, because that's another thing is when you are in court and you have allegations, whether it's your initial petition or the other party's answer, or somebody's not paying a bill, or somebody has some alcohol issues. Talk about the difference of presenting, you know, those issues in court versus in collaborative and how we deal with it.
You know, a lot of people don't realize that in Florida, everything that happens in the courts is public record. I could go down to the courthouse tomorrow and go into the clerk's office and start asking for files. They're going to hand me paper files, and they're going to give me access to every document that was ever filed. You don't have to be a lawyer to get this access. Anyone can, and they do. So everything that gets filed can be examined. It can be published in the public record. You can find it in the newspaper.
How much you make, how much you owe, allegations against your character and your behavior. I mean, and your kids can read it too.
All of your dirty laundry and much of your privacy is just non-existent. It's out there in the public record. No, they redact your social security number, but Believe me, you don't want people seeing your financial affidavit. So in collaborative, all of that can now be maintained confidentially. And we can arrange it so that absolutely none of that is in the public record. Of course, by the time you file paperwork with the court in an ideal collaborative situation, you have the agreement before anyone files the divorce, because you don't have to file the divorce. When you start with the participation agreement that the client signed, the participation agreement acts kind of like the petition that people file to start a divorce in the court. Most of the time, those agreements provide language that says, this is the day the divorce is starting, and we're going to treat this as the date of the filing of the petition for the legal reasons that that becomes an important date eventually, kind of like the cutoff date for the marital estate, so that retirement contributions made after that date of filing are non-marital. Debts acquired after that date maybe are non-marital, or whatever other items that the parties agree to treat the date of the participation agreement as a cutoff date. And it's just that it all of this keeps all of your information out of the public domain. Everything is confidential. In the highest asset case I ever handled was a collaborative case. And we ended up not filing actual financial affidavits. It was before they changed the rules that allowed us to just exchange them and not file them. But we filed, I guess I'm going to call them mock financial affidavits. It was a financial affidavit that understated things and put estimates. And it also, in the agreement, it said that the actual financial affidavits were being held by the financial neutral in case they were ever needed, but that they would not be filed with the court. And then we filed it in a sleepy county in West Florida that at the time really didn't have an electronic docket. I'm sure it does now, but we just kind of buried it so that it would be harder to find, because while I didn't know the husband before this case, I knew his job title with the and I knew the organization. So if somebody were of a mind to look up a very high-ranking official in a extremely well-known national organization, they would, and there were people who might look for that. So we tried to make it harder. So there are things that are available to keep a collaborative outcome confidential that are just not available in any kind of a litigated context, and sometimes not even in a mediated context.
And you can't, if you're litigating, there's some rules about where you can file. If you have real property and you're litigating, it has to be filed in that county. So you don't have those procedural choices. So collaborative.
This one family had properties in 3 states, including a Manhattan apartment, a country estate in Virginia, and then they had multiple properties in Florida. So that's a really good example. This could have been the biggest nightmare of 2 people who had money, but really weren't, like a lot of really wealthy people, they weren't really interested in spending it on their divorce, but they wanted a good outcome. They wanted a really good outcome. And they were working really well together because they weren't suffering from that anger, bitterness, and resentment that some people are experiencing when they're going through the divorce. And they wanted to do this way. They came to collaborative, knowing about collaborative and knowing that this is what they wanted. And we were able to navigate all of these issues over 3 states with properties and, many, many, many hundreds of millions of dollars in other assets and tax problems. The accountant, our neutral CPA, did the lion's share of the work. And it was well, well, well worth it, because it saved them. We probably saved them $1 million.
That
And
makes
that's the
sense.
feeling. As a professional, that's like, for me, that's like winning. I got my client the right result, a completely fair result, all the distribution of assets that she was entitled to. I happen to represent the wife in this scenario. Um, and yet she had a really good experience. She enjoyed the process. And as a professional, I enjoyed the process, and they got to keep their privacy. It couldn't be any better.
So Nancy, if somebody's listening and they want to have a consult with you about collaborative or a family issue, how do they find you? What's the best way to find you?
Best way to find us is at our website, which is www.bjblawyers.com. And my phone number is 954-344-7737. You can reach me through email through the website. And I'm pretty Googleable, so you can find me. But I do really enjoy collaborative work. I think that collaborative allows me and all professionals who really practice it, and by practice I don't mean dabble in it, but are dedicated to the principles and the immersion in the collaborative community, like Catherine and I are. We espouse these ideals and we enjoy living up to those ideals. And I get to show up as my best self. And that just is the most fulfilling thing that I can do. And without exception, even the cases that in the 10% or so cases statistically that are not resolved through the collaborative process, I will tell you that still another percentage of those end up resolving their case before a judge does, even if the collaborative process itself terminates. Sometimes mediation ends up being their answer and sometimes not. That it is, it's just the best answer for the parties. And I know that people really experience it as a good process. And all of them say, even if they didn't settle, they're like, I wish we could have. I know what the problem was, but they don't think it's the process that's wrong. So it's not for I don't believe that collaborative is the right process for each and every situation. I vet clients and their situations really carefully, because I had a lot of failures in the beginning, and that was mostly because I didn't realize who really wasn't a candidate yet. I was a little bit idealistic. Everybody can have a collaborative divorce. And with experience, I've come to believe that no, not everybody can. If the professional wants it more than you do, it's not good for a collaborative process.
It's their divorce. We're here to facilitate, but it's their divorce.
The client has to want it. And if one person doesn't really want it, it's not going to work.
Thank you for being on the FACP podcast. We appreciate your time.
A pleasure.